it's interesting at the directions hearing, the distinctions were made today before the court that there are issues to consider distinguishing those people who are citizens by birth and descent as opposed to those individuals who applied for citizenship and so would have had some knowledge of the distinction or knowledge of their other citizenship. So it's been raised in the context of a distinction between those two different types of ways of becoming citizens.
Right. Now, going strictly by Section 44 of the Constitution, which says any person who is entitled to the rights or privileges of a subject or a citizen of a foreign power means that MPs like Joyce or Canavan and Nash would then immediately be disqualified from standing. Their fate obviously sealed.
That's right. So on its face, it's very clear that anyone who does hold another citizenship is not entitled to be a Member of Parliament. The key issue that is going to be before the court is in light of the interpretation of the purpose of that section, and the earlier case that had been held by the court recognised that there might be a scenario where a country, say for instance a neighbouring country, Indonesia, determined tomorrow that every Australian is also an Indonesian citizen. Well, on the face of the provision in the Constitution, that would disqualify everybody from being a Member of Parliament. So they said there had to be some reasonableness in the measures of identifying when someone was in fact a citizen of another country. Now, that's why we're seeing the discussion about, is there a distinction between someone who is born a citizen or a citizen by descent as opposed to someone who's applied for citizenship. But on its face, there really is no difference between those two types of citizenship because each of them provide in a normal and reasonable way for an individual to become a citizen.
The fate of a government hangs in the balance here by their decision. Now, if the High Court doesn't go by the letter of the law, according to the Constitution, does this mean we're about to see the High Court take on judicial activism like we've seen in the US?
Well, we see the High Court always interpreting provisions of the Constitution. So, for instance, when this was heard, the most recent case was the case of Heather Hill, who was a British citizen. And at the time of the Constitution, British subjects were actually equivalent to Australian citizens. So the court has looked at the evolution of the meaning of the term British subject and the evolution of the term citizen to interpret this section. That's a normal interpretive role of a court, to identify its meaning in a particular time. So the question here is there a significant difference from that period? And arguably there is no difference. And so it really will be a matter of constitutional interpretation. And it is the role of a court to interpret a constitution according to the framing of the Constitution and its intention, as well as its application.
Now, just bear with me here. It's something that someone pointed out to me, that Section 46 states that any person declared by this Constitution to be incapable of sitting as a senator shall be liable to pay the sum of £100 to any person who sues for it. Now, does this mean that these MPs, should they be found to have breached the Constitution, could then be sued by any member of the public?
So that section, actually, you missed the very first words, which is until the Parliament otherwise provides. So in fact, Parliament has actually provided a piece of legislation since the framing of the Constitution, which substitutes that provision for a different monetary sum and does require an originating suit. So there is a framework for an individual to sue, but there is a context also in which this has been updated in effect. So there are some provisions, which is really interesting, as you've just identified, that have a provision for until the Parliament otherwise provides, whereas Section 44 doesn't have that section. Section 44 is a blanket requirement. So it's not a matter of Parliament being able to change this. We would need the people to change Section 44 in order to enable individuals who are dual citizens to be able to sit in Parliament. And there's another whole policy issue, which of course we could discuss about that.
Exactly. Well, I want to take you up on that particular issue. You said that people would have to change it. If it is deemed that the Constitution, this particular section, is antiquated and no longer relevant, are we about to see another referendum?
Well, that certainly would be the way to move forward. And I think this would be an example of an area where you could actually get bipartisan support. And in fact, a different way of portraying what's happening in our parliament at the moment is actually a representation of the success of Australian multiculturalism. Within one generation, we have children of migrants who are already being active citizens by becoming members of parliament. What a great success story that is for Australia, and we need, as we could have bipartisan support to affirm Australian multicultural success by the need to change this section. And I think that there are better ways of dealing with the underlying issue of this section, which is the question of conflict of interest. And there would be better ways of maintaining, for instance, a register in Parliament of people who have other citizenships, so that if there is some discussion in Parliament about an issue that may raise questions about a person's connection to another nation state, we can discuss that openly in Parliament, and that could be a basis upon which people make decisions, as opposed to a formal requirement to renounce citizenship, which may be done formally but may not actually represent a change in that person's sense of connection or commitment to the other country in a particular context.